This is Makhdoom Shahabuddin, and tonight we dive into one of the most important, most transformative, and most contested debates shaping Pakistan's future: the constitutional reform of our judicial system. From British colonial codes written in the 1800s to modern constitutional crises in 2023, 24, and 25, to sweeping structural changes introduced by the government today, Pakistan's judiciary stands at a crossroads. Some say modernization is overdue. Others warn that abrupt structural shifts may weaken an already fragile balance of power. Tonight, we trace this journey from inheritance to reform, from evolution to controversy, and from government claims of efficiency to expert concerns about oversight and institutional strain. Let's begin. Pakistan's judicial architecture didn't begin in 1947. Its roots stretch back almost 1500 years through four major legal eras: ancient Hindu legal traditions, Islamic and Mughal jurisprudence, British colonial rule, and modern constitutional Pakistan. But it was the British legal legacy that truly shaped the structure we still operate under today. The legal backbone of Pakistan today still rests on the Indian Penal Code (IPC), drafted in 1860, the Code of Criminal Procedure (CRPC) from 1898, and the Code of Civil Procedure (CPC) from 1908. These laws were designed not for a democracy, but for administering a colony. They were meant to maintain imperial authority, not ensure citizen-centric justice. And yet, they continue to shape how Pakistan's courts function in 2025. The contradiction is clear. A modern constitutional democracy operating with procedural tools written 140 to 160 years ago, designed for a completely different social, political, and administrative reality. This mismatch is a major cause of delays, complex procedures, outdated evidentiary rules, and the Pakistan's massive backlog of over 2 million pending cases. Ladies and gentlemen, as society evolved, technology evolved, crime evolved, our laws stayed nearly frozen in time. This is why globally judicial reforms is known as normal, healthy, and necessary. Countries modernize laws routinely. Pakistan, however, modernized slowly until now. When Pakistan adopted the 1973 constitution, it attempted to bridge the gap between colonial law and modern governance. The constitution gave the judiciary independence from the executive, financial autonomy, the power to interpret the constitution, and the responsibility to preserve, protect, and defend the constitutional order. The Supreme Court became the ultimate guardian, with broad appellate powers, original jurisdiction, and suo motu authority. But over the last 5 decades, Pakistan's judiciary has operated in an environment unlike most democracies. Repeated military takeovers, constitutional dissolutions, executive overreach, political instability. As a result, the courts developed assertive judicial activism, a stronger role in political oversight, and in some cases, direct influence over political processes. Supporters call this a necessary check on state abuse. Critics say it created excessive judicial intervention in executive matters. Either way, the judiciary became a central actor in Pakistan's political battles. This brings us to the present. According to lawmakers, experts, and even former justices, judicial reform was not only expected, it was inevitable. 3 major pressures built up over decades. Number 1, outdated laws. CRPC, CPC, and parts of the evidence law cannot serve a modern society or modern crime environment. For example, Pakistan still struggles to reconcile DNA evidence with certain traditional presumptions in paternity cases, a direct clash between modern science and old jurisprudence. Number 2, massive cases backlog. Over 2 million cases are pending, civil cases taking 10 to 15 years, criminal trials dragging on for decades. And number 3, unclear institutional boundaries. Suo motu powers, bench formation, and constitutional oversight often became politically controversial. Number 4, the national debate. Political actors argued that reforms were needed to reduce judicial overreach, streamline case distribution, improve efficiency, and update the colonial era procedures. This set the stage for the major legislative wave beginning in 2023. Over the past 3 years, Pakistan has undergone the most significant judicial restructuring since 1973. These include a Supreme Court Practice and Procedure Act 2023. Government's claim is that the law ensured transparency by placing suo motu cases before a panel of 3 senior judges instead of giving unilateral power to the Chief Justice. Legal experts noted the intention may have been good, but questioned whether Parliament should be regulating internal judicial procedures, something typically managed by the judiciary itself. B. The Constitutional Amendment 2024. This amendment modified the appointment powers for senior judges. Government's claim is that the amendment increased accountability and made judicial appointments more democratic by involving Parliament in the nomination of the Chief Justice. Critics argued this could reduce judicial independence as elected governments would gain influence over appointments traditionally insulated from politics. And C. The 27th Constitutional Amendment in 2025. This was the most sweeping and biggest reform to date. It introduced a new Federal Constitutional Court, the FCC, clear division between constitutional and appellate work, modified the suo motu jurisdiction, and new mechanisms for appointing and transferring judges, adjustments to the military command structure, Article 243. Ladies and gentlemen, the government said the amendment would reduce the Supreme Court workload, speed up the constitutional cases, improve federal representation, and create institutional balance. However, analysts agree modernization is needed, but caution. Major structural changes required broad cross-institutional consensus. Abrupt transitions can cause uncertainty. The new court could create overlapping jurisdictions if not implemented carefully. Changes to the Supreme Court's authority must be approached with transparency. In short, reform is necessary, but reforms must be stable, predictable, and consensual. Ladies and gentlemen, while constitutional engineering dominates the headlines, Pakistan's core judicial problems are much more basic and urgent. Number one, the colonial era procedures. Criminal investigations still follow rules from 1898, written before the forensic labs, modern policing, digital evidence, organized crime, cybercrime. Number two, the forensic evidence gaps. Pakistan still faces judicial hesitation in using DNA in sensitive paternity cases, revealing the tension between scientific evidence and traditional legal presumptions. Number three, the vulnerable citizens' outdated laws on land evictions, inheritance, minority protections, and this leaves citizens, especially the marginalized groups, vulnerable to abuse. Some reports have documented misuse of laws and in land disputes, blasphemy, allegations, and inheritance claims. And number four, slow civil justice. A civil suit can take 10 years to start, 15 years to finalize, and sometimes 20 plus years to conclude. In a modern economy, such delays discourage investment and weaken the public trust. Ladies and gentlemen, around the world, judicial reform is considered routine. In Azerbaijan, digital transformation tripled the judge productivity and raised citizen satisfaction from 44% to nearly 70%. In the United States, alternative dispute mechanisms like mediation and arbitration reduce the court burden. Global legislatures, modernization focusing on simplifying the laws, reducing delays, integrating technology, clarifying institutional roles. Globally, modernization is seen as a healthy, necessary process, not a political conflict. But Pakistan's challenge is ensuring reform strengthens the judiciary instead of straining it. Ladies and gentlemen, Pakistan stands in a delicate moment. On one hand, the system absolutely needs modernization. Everyone agrees on that. On the other hand, how reforms are designed and implemented matters just as much as the reforms themselves. The government insists that reforms are meant to increase efficiency. Dividing constitutional and appellate work is necessary. FCC will improve the federal balance. New structures will stabilize governance. Suo motu regulation will prevent legal uncertainty. Judicial transfers will become more transparent. Modernization is overdue and unavoidable. But some jurists say that reforms require broader consensus. Implementation must be gradual and carefully sequenced, and parallel courts can create legal confusion. Judicial independence must remain intact. Institutional stability requires coordination between the state organs. This is not a clash of for or against. This is a debate on method, timing, and institutional balance. Now let's go out to the public and see what they have to say about the judicial reforms.
देखें जी, जो आवाम का एतमाद है वो तो हमेशा से ही अदालतों पर बहाल ही है, ठीक है। लेकिन ये कि अगर ये जो 27वीं तरमीम आई है, अगर आवाम के लिए और हमारे मुल्क पाकिस्तान के लिए बेहतर है और हमारे जो इलेक्टेड नुमाइंदे हैं वो समझते हैं और हमारे जो अदारे हैं वो भी समझते हैं कि ये बिल्कुल बेहतर है, तो ये बिल्कुल बेहतर है, इसको होना चाहिए, ठीक है। आवाम को देखें, आवाम की मुख्तलिफ़ प्रॉब्लम है, उनको इंसाफ नहीं मिलता, कुछ लोगों के रोज़गार के मसले हैं, कुछ के मुख्तलिफ़ चीज़ें उनके आड़े आ जाती हैं, ठीक है। लेकिन जो आवाम की ज़रूरत है अगर वो ऑन टाइम पूरी हो, बिलफर्ज ख़ास तौर पर इंसाफ हो, ठीक है, तो बिल्कुल सर इसको आना चाहिए, बहुत ज़रूरी है, बड़ी अच्छी चीज़ है हमारे मुल्क के लिए।
लेकिन ये बेंच ज़्यादा बनेंगे, जज बैठेंगे, मतलब लोगों के फैसले जल्दी होंगे। सारी बात जो केसेस डिले पड़े हुए बहुत सारे, मतलब आपको पता है जुडिशली ये सिस्टम है कि कितने बहुत पुराने केस अभी भी शायद पड़े हो वहाँ पे। सारी बात जब चीज़ें बेहतरी होगी तो सारी बात है हमारे लिए बेहतर होगी, आवाम के लिए बेहतर होगी।
लेकिन जी अगर पाकिस्तान के लिए, पाकिस्तान के अवाम के लिए अगर ये बेहतर हुआ तो बहुत अच्छा है। तो इस तरह तो पहले भी बहुत सारी चीज़ें आती रहती थी, लेकिन उस पर उस तरीके से फिर अमल नहीं होता जैसे होना चाहिए। तो हम तो कहते हैं पाकिस्तानी इस अवाम के लिए जो भी हो, बेहतर हो, अच्छा हो, तो वो फिर पाकिस्तान के लिए भी अच्छा है और सब इदारों के लिए भी अच्छा है और सब पार्टियों के लिए भी अच्छा है।
Welcome back. Ladies and gentlemen, regardless of the political viewpoints, Pakistan's judicial system needs digital courts, the case automation, e-filing, and AI-based scheduling. Number two, updated procedural laws. CRPC, CPC, and others need modernization with full forensic integration. Number three, alternative dispute resolution to reduce the civil case burden. And number four, better investigation quality. Trained forensic teams, digital evidence units, modern police reforms. Number five, clear jurisdiction boundaries to avoid conflicts between the courts. Number six, consensus-based constitutional reform. Stable, durable changes require national institutional agreement, not just parliamentary majorities. Number seven, the protection of judicial independence. Regardless of the structure, independence must remain non-negotiable. Ladies and gentlemen, Pakistan's judiciary is not just a legal institution. It is the backbone of democracy, governance, rights, and national stability. Reform is necessary. Modernization is necessary. Updating colonial laws is necessary, but the path forward must be balanced, consensual, transparent, institutionally stable, and aligned with constitutional spirit. Today, Pakistan stands between two realities: a system rooted in the 19th century and a world accelerating into the 21st century. History shows that countries which modernize their legal systems thrive. Those that delay fall behind. Pakistan's challenge and opportunity is to modernize without destabilizing. This story is far from over. This is Makhdoom Shahabuddin. See you in the next episode.